Welcome to This Week in Family Law, the go-to podcast for busy Australian family lawyers looking to stay updated without the overwhelm. My name is Jenna Downey and I'm a family lawyer and the Managing Director of Leap Family Law. I have my co-host for this episode here with me, Antonia Cacapato. How are you, Antonia?
I'm good, thanks, Jenna. How are you?
I'm good. Now that we're in March, I wanted to ask you how your CPD points are coming along.
Yeah, getting there. Just need the last one, the ethics one. That's always the hardest.
I've heard that from so many practitioners.
How about you?
I think I have all my points, which I'm very happy about.
So good. Perfect. Well, let's get into it. What's up, Jenna?
For the first update I wanted to share today, it's from the Law Institute of Victoria, which they've published an article based on their new podcast called Cross-Examined, where they spoke to the Honourable Richard Nile, Chief Justice of the Supreme Court of Victoria, who says the adoption of AI by governments, the public and the legal profession makes its adoption within the courts inevitable. AI is being tested within the judicial system, including a pilot program at the Coroner's Court of Victoria, with the idea that it will help reduce the time of investigations and staff's exposure to distressing events. Another example they outline is the Supreme Court exploring how AI can assist judges with administrative back-end type of tasks in completed cases. It goes on to mention the risks of AI, of course, which I'm sure everyone
is well aware
of. In terms of hallucinations and how the lawyers have duties to the court, so they should ensure that anything that is handed up to the court is correct or said to the court is correct, and also the growing threat of deep fakes as well.
Yeah, that's really interesting. I'm glad to see that the courts are adopting the use of AI because it really is the way of the future.
Well, it's certainly a matter of time, isn't it?
Exactly. I saw another article on the ABC, not exactly family law related, but interesting nonetheless. A Korean-born Australian has successfully overturned her adoption during attention to alleged inconsistencies in South Korea's historic overseas adoption system and increasing pressure for an Australian federal inquiry. The woman, who had been adopted into Australia as a baby, challenged the legality of her adoption after discovering inconsistencies in records and evidence suggesting she may not have been an orphan as previously claimed. The woman was also a victim of sexual abuse and physical abuse, and knowing her child abusers were listed as her legal parents was very distressing for her. Supporters hope the case will encourage other adoptees seeking answers about their origins and push governments to improve transparency, access to records and accountability for past adoption practices.
Wow, that's so interesting to hear, especially as adoption in Australia, as far as I'm aware, isn't that common.
No. And there were, in the article, they spoke about this agency from South Korea having over 3,600 children who may be affected by this.
It's horrible.
I'll keep an eye out to see what happens with the federal inquiry.
Please do. I'm very keen to hear an update on that, and I'm sure our listeners are as well.
Yeah.
Our next update is in relation to the new AML regime that's coming into place. The head of AUSTRAC, CEO Brendan Thomas, said that criminals are its focus with these reforms. Administrative glitches from law practices won't be punished. AUSTRAC recognises the pressure that many legal practices are under as they prepare to meet their obligations under the new reforms. While AUSTRAC is not expecting perfection, law practices should apply their best efforts to comply. And I think that's worth sharing because I know a lot of practitioners that I've spoken to they do feel pressured at the moment to make sure that they have this right.
Exactly.
And just to reassure them that AUSTRAC are aware that some errors, let's say, may occur initially as we try to work out the way forward.
Yeah, with the new process, there will be some teething issues, but good to see that they're not going to be, criticised if there are errors in their work.
Yeah.
I wanted to discuss as well with the International Women's Day just preceding us. We had our first Leap Family Law breakfast where we had we were joined by Mel Thomas from the Key Up Project, John Yates, QPM, and Sarah McGalvery, where we discussed violence against women and children, which is something we come across in the practice of family law. We were also lucky enough to complete the Key Up Project workshop and learnt some fundamentals in self-defence and then break the wooden board. So that was a lot of fun.
It was a lot of fun, and everyone was so surprised that they could actually break a board and felt really empowered after as well.
It was a really empowering morning and lovely to be a part of it. We also have the 2026 Asia Pacific Coercive Control and Children Conference coming up this week at the Roundhouse in the University of New South Wales. This one is in person but also virtual. So if there are practitioners who do need those last few CPD points, I would suggest having a look into this, and we'll put the link in our show notes.
Thank you. The final update is from the Family Court of Western Australia, who were pleased to announce some new appointments. Registrar Andrzej Meisner, and I hopefully have pronounced that correctly, has been appointed as a family law magistrate following the retirement of another magistrate, and 3 appointments have been made as registrars of the court as well. And I feel like we always do share these updates in relation to appointments, but it's always good to hear that there is someone being replaced once they do retire, and that new appointments are being made.
Yeah, no, that's a wonderful update to have. Thank you, Jenna.
Thank you for joining me, Antonia, and that's what's up for this week. We have an exciting Case Note Corner this week where we deep dive into pop culture stories and discuss them with an Australian lens and look at the legal issues that are part of them and how cases may have played out in the Australian courts versus what Antonia is going to talk about in the States. Antonia, I'm very keen to hear about your case note this morning.
We thought we'd try something a bit different. So I wanted to talk about spouse maintenance, but under the lens of what happened with the singer Kelly Clarkson, which I'm sure everyone knows about, 2002 American Idol winner. She was married to her former husband and manager, Brandon Blackstock. They were together, married for almost 7 years, and they filed for divorce in 2020. And they had 2 young children at the time who were 6 and 4 at the time of separation. Sadly, Brandon has passed away from skin cancer last year, but this all transpired in 2022 to 2024 is when the spouse maintenance payments were. So the headlines that came from this were she was ordered to pay him spouse maintenance of $115,000 per month, and then on top of that, a further $45,600 in child support.
Wow.
Yeah. Insane. Not something you'd hear of really happening in Australia. And so apparently he was asking for $436,000 a month, and the court ordered the $115,000. These were required from March 2022 until January 2024, and they totaled over $2.5 million in spouse maintenance payments. He also received a $1.3 payment as part of their financial settlement. They had a prenup in existence, so they're in the American law, they only marital property really gets divided, but the way that the prenup was drafted was she got to keep everything from prior to the relationship, and then there was a argument about the ranch because he was living at the ranch, but she ended up keeping it, and it was worth $17 million. An interesting note, though, which again we wouldn't really see in the Australian courts, is he got to keep 5% of that ranch, an interest in it. So that totaled about $900,000. But in Australia, with the Section 81, where the court really wants to sever the financial ties, you wouldn't really see the court ordering that they keep joint property.
Yeah. Do you know what the justification behind him still having an interest in what was her property post-separation?
Unfortunately, the articles that are out don't go into the reasoning behind it, and I couldn't get the actual judgment for the settlement. But there was just a lot of back and forth there, so I think it might have been her giving him that rather than the courts actually ordering it.
Sure.
Yeah. So the assets that were awarded to her, she did get to keep the 2 properties. He got to keep all the farming equipment. It seemed as though she did have a good prenup in place, and the physical custody of the children was predominantly with her. And she got to keep all the guns, which I'm sure Americans would love.
Lucky her.
There was also a cross-jurisdictional litigation case going on where she ended up suing him because he didn't have the correct talent license to be acting as her manager, and she ended up being awarded $2.6 million there as well. So there was quite a few cases going on in the background, but what I want to discuss today mainly is the spouse maintenance and how, when you hear a case like this, you think, how would it play out in the Australian courts? Because as you're aware, and most of our listeners would be aware, in Australia, the power to grant spouse maintenance claims is under Section 72, where there's the two-limbed threshold test of whether the applicant has the need and whether the respondent has the capacity to pay. In the United States, they don't have that rigid two-limb test, but they consider other factors to keep the marital standard of living for the applicant. So they consider the duration of the marriage, they consider the age, health of parties, income and financial resources, ability to obtain employment, and care of the children. So that would all sound really familiar to you, but in Australian courts, we deal with that mainly in the property settlement. It is also considered in spouse maintenance, but you have to cross that first threshold, which is interesting to see that they don't have that in the US courts. Another point was that with the length of the marriages under 10 years often approximate to spouse maintenance being awarded for half the length of the marriage. So with a 7-year relationship, she could have seen to be paying him for 3.5 years. And then any marriages that are longer, so 10 years plus, could be indefinitely awarded. So that's very different to how our courts would.
It's very different, isn't it? And I have heard, speaking to people in the UK, Canada, and the States as well, their spousal maintenance is definitely more long-lasting rather than what we try to do in Australia, which is deal with everything as part of the property settlement.
Exactly.
But if
cut
there
their
was
ties
but if a spousal maintenance order was to be made post property settlement, it is generally for quite a short period.
Very, very short, because they don't want that. And also trying to enforce it. Imagine if you get this spouse maintenance and then he's like the respondent isn't paying what they need to. The cost of having to go down the route of enforcing that spouse maintenance order, I think our courts really deal with that well by wrapping it all up in the property settlement. Another really interesting point to note was that spouse maintenance is only available to married spouses and registered domestic partners. So if you're living as a de facto couple, you're not eligible for spouse maintenance. Conversely, in Australia, the de facto partners have the same rights as married couples without having to register the relationship, which I found really interesting.
Yes, our de facto partners are definitely covered by our legislation, the same as married couples in Australia.
I know. We're very lucky here with that. Oh, depends which way you look at where you're coming from. And also, one other thing I found interesting was the effect of cohabitation and remarriage on spouse maintenance. Here, cohabitation is considered relevant when considering spouse maintenance. However, in the US, cohabitation creates a presumption of a decreased need but doesn't necessarily remove the spouse maintenance payment. However, remarriage of a supported party does terminate the support. Yeah. So taking this all into consideration and how Australia does like to focus on severing financial ties when completing a property settlement, I'd like to know your thoughts on how this would have played out in Australia if, they didn't have a prenup or anything. So taking the facts, a 7-year marriage, 2 young children, Kelly coming in with greater initial contributions, a $45 million pool approximately. Brandon having worked for Kelly, however, he did have his own agency where he would also have had other talent he managed, so clearly had his own income. Forget about the other litigation where he would have had to pay her the 2.6. How do you think this would have played out in Australia, assuming there was no valid prenup?
If there was no prenup, it would have been dealt with as a usual property settlement under Section 79 of the Act, in which case her initial contributions would have been taken into account, and over a 7-year period, they would have been given weight.
For sure. It's a medium length of a relationship. Yeah.
Absolutely. And then the contributions during the relationship would have, of course, been looked at, and then their current position in terms of earning capacity and their future circumstances as well.
Yeah. So I think he would have just, with step 3 of the step 4 of the 4-step process, he would have been given a greater adjustment rather than having this ongoing spouse maintenance to make up for the income disparity.
Yes.
Yeah, which I think is a much cleaner way
Absolutely.
of doing things,
Yes.
and then they can just go and live their lives.
Yes.
Yeah.
I agree. It's interesting, isn't it? But I'd imagine that because the spousal maintenance in particular is such a thing over in the States and in other countries as well, that particularly post property settlement, that they must have a reasonable way to deal with that. And as you were saying before, in terms of if someone didn't pay, how would they recoup payment?
Yeah, exactly.
But surely that issue would come up so much because it's like spousal maintenance is ordered.
Yeah, they'd have to garnish your wages or something, you know. But again, it's the enforcement of it. It's always having this over your shoulders. Is he going to pay this spouse maintenance today, rather than, or is she going to pay this spouse maintenance today, rather than just knowing how much money you have and you work with that, and then you go on your merry way.
It's a bit like child support, isn't it? I know people do prefer to enter into binding child support agreements where they might have a little bit more confidence in payments being made rather than just through the child support agency, whether that's through periodic and or non-periodic payments. I've had some clients who would only want periodic payments, not periodic payments because they didn't think that their ex-partner would actually pay third-party providers, and then vice versa as well. So everyone's got their own spin on it.
Yeah. Or paying the third party directly so that they don't have to be involved in collecting the money.
Yes, but enforcement definitely comes up a lot.
Yeah. And to wrap up, do you think Kelly would have done better in Australia or in the US?
That's a tricky question. In Australia, I know that Kelly probably would have had to have paid more by way of a property settlement. But on the flip side to that, she wouldn't have had to pay these ongoing significant spousal maintenance payments.
Yeah, I agree with you there. But if you were pushed to pick a side, which one would you pick?
Ooh, I would say that in Australia, perhaps she was better off because at least she is paying whatever she needs to upfront, if I can put it like that, and there's not that ongoing liability that she's going to continually have to support him.
Yeah, I agree. I think a strong sever of the financial ties is the way to go. Australia's got it right.
Thank you, Antonia. And that's our case note for this week. For your questions answered this week, we have 3 listener questions. The first one is from Mel. I'm not a lawyer, but I'm going through a separation. What advice would you give to someone about to separate?
That's a good question. I would take things slow. Don't do anything drastic like transfer assets or agree to transferring assets away or agree to an informal arrangement. I would go and get legal advice straight away.
Yeah. I think even before you are close to separating, which there's a lot of people who think about it for so long, to get some legal advice does put you in such a good position ahead of time, just to understand your rights and your obligations.
Exactly.
And you can make some more informed decisions that way.
Yeah, so many people would come in practice when they're just thinking about separating and they wouldn't know half of what we tell them because you get this pre-perceived idea of what, the 50-50, they're going to take all my stuff. It's like, no, we look at that in a more detailed manner. And getting that specialised advice from a family lawyer, I'd say family over any just general practice because it's something that you see day in, day out. And just making sure you've got your ducks in a row before you make any big steps. Yeah.
I also feel like that once people have an initial consultation, no matter what point they are at with their separation, whether they haven't yet separated or it's just happened or they've been separated for a period of time, that the person walks out and they do feel more comfortable and almost a sigh of relief because probably what they thought and what they might hear isn't true, that there aren't presumptions or, they're not going to not get time with their children if they're, unless there's a particular reason why.
Exactly. They feel more at ease once they get that advice about their specific situation.
Yeah, absolutely. Yeah. Thank you. Our next question is from Matt. I have just become aware that my client has altered a hair follicle test. I'm not sure if this is through AI or Photoshop. How do I deal with this?
Gosh, this would be coming up more and more with deep fakes and AI. I had a matter similar to that in practice where subpoena material came back and we realised our client had actually altered her hair follicle test, and we ended up getting rid of her as a client because it was just so untrustworthy, and you don't want to be acting for people like that. So I would tell Matt to really consider acting for this person. Call the ethics hotline if you're not too sure as well, the Law Society hotline, and speak to them. But I would not go further with that client.
Yeah. And clients do seem to do some crazy things when they're in such emotional turmoil and going through a separation. I'm sure this isn't the first time that this has happened. As you said, you've experienced it. I've had clients that have altered letters sent from the alleged other solicitor and all of that, which is crazy.
Yeah, it's not.
But
great.
But in people's mind, justified when they're going through a difficult situation.
Yeah, exactly. What happened in your situation when clients did that?
We realised, we spoke to the client about that, and we had to have a conversation with them. I don't know if we even needed to step back from acting. I think he just decided that he just didn't contact us any further, and
probably embarrassed.
He moved on.
Yeah. Okay.
And our third question is from Angela. I have just found out I have a matter against a lawyer I didn't have a good experience with because they were nasty and this knocked my confidence. How do I deal with a difficult or unreasonable opposing lawyer?
Oh, sorry to hear. That's never fun when you get your confidence knocked, in court or in practice. I would just not take it personally. Sometimes lawyers become are really hard to deal with, but it's more them than you. So I would just look at the facts of the case, and any phone call you have with them, put things in writing afterwards. If you don't feel comfortable having phone calls with them, just keep it to letters and emails, and just pick your battles. Don't, you want to win your client's case. You don't need to win every argument against the lawyer. So really just keeping that interaction just very professional and concise to the point.
Yeah. And I think also if that person has a senior practitioner in the firm that they can lean on and they can speak to about this to make them feel a little bit more comfortable dealing with this person, then that could also help.
Yeah, definitely. That's a great suggestion.
Thank you, Antonia. I'm sure our listeners have enjoyed having their questions answered this week. We've loved being in your ears this week. Please rate and review us to help this podcast get in front of more people. And if you have any questions, as always, please email us at familylawpodcast@leap.com.au, or you can reach us on socials, including Instagram, TikTok, and YouTube. Stay tuned for next week's episode. New episode drops every Monday.